Hello friends, today we are going to understand the details of section 163 of the BNSS. Previously it is section 144 of the CrPC and we are going to in detail for this section. Section 163 of the Bharatiya Nagrik Suraksha Samhita 2023. Imagine that two rival groups plan a processions on the same road at the same time. The administration receives credible information that violence may occur. Should the magistrate wait until people are injured, property is damaged? No. Section 163 of the Bharatiya Nagrik Suraksha Samhita 2023 or BNSS allows preventive action in such urgent situations. This provision replaces the well-known Section 144 of the Code of Civil Procedure, Criminal Procedure 1973. In this video, we will understand the provisions, its safeguards, and two important Supreme Court judgments. Purpose of Section 163. Section 163 is titled Power to issue order in urgent cases, nuisance or apprehended danger. This is primarily a preventive provision. Its purpose is not to punish person for an offense already committed. Its purpose is to prevent an expected danger before it occurs. The three key ideas are: 1. There must be sufficient grounds for action. Second, the situation must require immediate prevention or speedy remedy. Third, the restriction must be connected with specific danger mentioned in the section. Therefore, Section 163 is an emergency power. It should not be used as a routine method of administration. Who can issue order and why? An order under Section 163 may be issued by a district magistrate, a subdivisional magistrate, another executive magistrate specially empowered by the state government. The magistrate may direct a person to abstain from a particular act or to take a particular action regarding property in that person's possession or management. The order must be intended to prevent obstruction, annoyance, or injury to a person employed, the danger to human life, health, or safety, the disturbance of public tranquility, riot, affray, meaning fighting in a public place that disturbs public peace. For example, the magistrate may temporarily regulate a procession, prohibit carrying weapons in a sensitive area, restrict entry into dangerous location, or control an activity that may cause a riot. The most importantly, order must be in writing and must state the material facts of the case. A vague statement such as there may be a law and order problem should not be sufficient. The order should explain the facts, urgency, anticipated danger. Ex parte and general orders. Section 163 permits an ex parte order, meaning an order passed without first hearing the affected person. This is permitted only in an emergency or when there is not enough time to serve prior notice. The order may be directed against a particular individual, persons residing in a particular area, persons visiting, frequenting that area, the public generally in relation to a particular place. A general restriction may sometimes be necessary, especially where a large gathering makes it impossible to identify individual troublemakers. However, the restriction should not be wider than a danger. If the problem concerns one street, restricting an entire city would require a very strong justification. Duration and remedy. An order issued by magistrate cannot remain in force for more than 2 months. The state government may extend it by notification, where this is necessary to prevent danger to human life, health, safety, or a riot or affray. The additional period cannot exceed 6 months from the date on which the magistrate's order would otherwise expire. An affected person may apply for alteration or cancellation of the order. The magistrate or state government must provide an early opportunity to appear personally or through an advocate. If application is rejected, the authority must record the written reasons. These requirements protect citizens against indefinite or arbitrary restrictions. Section 144 versus Section 133 of the BNSS. BNSS is a substantially successor to Section 144 of the CrPC. The main legal framework remains largely the same. The competent authorities are the same. The order must be written. The material facts must be stated. Ex parte orders are permitted in emergencies. Individual and general orders are possible. The normal maximum duration remains 2 months. The state government may grant the statutory extension. An aggrieved person may seek alteration or cancellation. Therefore, the most visible change is renumbering from section 144 to section 163 along with the corresponding references under the BNSS because the core language of the legal structure remains substantially similar. Earlier, Supreme Court judgments on Section 144 continue to provide important guidance for the interpreting Section 163. Babulal Parte case in Babulal Parte versus State of the Maharashtra decided in 1961. Rival labor unions planned demonstration and counter demonstration. Apprehending a breach of peace, the district magistrate prohibited assemblies of 5 or more persons in specified area. For 15 days, the petitioner challenged Section 144 as violating freedoms of the speech, peaceful assembly under the Article 19 of the Constitution. The Supreme Court upheld the provision. It observed that the power exists to prevent disorder and protect the public welfare. It is entrusted a response to responsible magistrate. The restriction is temporary. The magistrate must satisfy himself about the relevant facts. The power can be used only in an emergency and for the purpose specified by the law. The court also clarified that possibility of misuse does not automatically make a legal provision unconstitutional. The main lesson is this is a limited and purpose specific preventive power, not an unlimited power to control the citizens. Second, Madhulimaye case in Madhulimaye versus Subdivisional Magistrate Mangier decided in year 1970 and reported in 1971. Seven-judge bench again examined the validity of Section 144. The Supreme Court said that gist of the provision is urgency of the situation and likelihood of preventing harmful consequences. The court explained that it is not an ordinary administrative power. The emergency must be sudden. The anticipated consequences must be sufficiently grave. The power must be exercised in a judicial manner. The order remains open to judicial scrutiny. A general order may be justified in some situations. An excessively broad order may be legally challenged. The most important learning is urgency gives authority power to act, but it does not remove the legal accountability. Conclusion: remember these 5 points. Section 163 is a preventive, not ordinarily punitive. 2. There must be genuine urgency and relevant material. 3. The order must be written and supported by material facts. 4. The restriction must be temporary and proportionate to the danger. 5. The order can be reviewed, modified, or challenged. Section 163 balances two important interests: the state's responsibility to protect public safety and citizens' freedoms of speech, movement, and peaceful assembly. The spirit of the provision can be remembered through the one formula: real urgency, relevant facts, written reasons, limited duration, and judicial scrutiny. That is section 163 of the BNSS in simple language. Thank you.